हेलो सृष्टि मैडम, सुन पा रहे हैं?
जी सर।
ओके।
सर स्टार्ट करें।
यस।
A very good afternoon to everyone. I, Srishti Dixit Soni.
रोक देना सबको ना, नहीं आने देना किसी।
Good afternoon, everyone. I, Srishti Dixit Soni, on behalf of the Faculty of Law, Mangalayatan University, Jabalpur, welcome all of you to this webinar on reforms in criminal laws in India. We have amongst us the Vice Chancellor of Mangalayatan University, Jabalpur, Professor Dr. KKRS Samasiva Rao, sir, our Pro-Vice Chancellor, Professor Vinika Kaur Saluja ma'am. I request the head of the department, Dr. Neeraj Prakash Rai, sir, to kindly welcome our guest speaker, Dr. Aditi Singh, Associate Professor, Woxsen University, Hyderabad. I request Neeraj Prakash Rai, sir, to please welcome our guest speaker.
Thank you, madam. I would like to welcome our speaker, Dr. Aditi Singh, Associate Professor, Woxsen University, Hyderabad. I would also like to welcome Professor KRS Sambasiva Rao, sir, Vice Chancellor, Mangalayatan University, Jabalpur. I am also welcome Professor Vinika Kaur Saluja, Madam, Pro Vice Chancellor, and Dr. S. Naga Kishore, Registrar, Sir, Mangalayatan University, Jabalpur, Madhya Pradesh. And a warm welcome to all the guests and participants in this webinar entitled. I further request Srishti Soni, Madam, to kindly brief about the journey of the chief guest. Please take, Madam Srishti.
The guest speaker of today, Dr. Aditi Singh, has dual specialization in human rights as well as criminal law. She has been recently associated. Please everyone mute your mic, everyone. She is recently associated with a project of National Human Rights Commission on the status of old age homes and protection of rights of the elderly in the 7 northern states of India. She has been part of various other projects like status of access to justice in India and many more other projects. She has a teaching experience of more than 10 years and is a dedicated academician with passion for research and teaching. She has contributed various chapters like the pendency of court cases in India and the status of legal aid clinics in law colleges in India, both of which were conducted by GGSIPU in association with the Ministry of Law and Justice, Government of India. Besides this, she has contributed various articles in various national and international journals. Ma'am, I extend a warm welcome to you. Please address this webinar as we all are eagerly waiting for you for your valuable insights on the subject.
Hi, good afternoon, everyone. Am I audible?
Yes, ma'am.
Yes, ma'am. Okay. First of all, I would like to thank the university for inviting me for this webinar. So I've just been told that the students are having their examinations. So I don't want to basically take a long time. But then this is something which is very important and relevant. Srishti ma'am, as I am speaking, I have actually shared my PPT with you. If it's possible, can you put it? I tried to share it by myself, but I wasn't able to. So I've sent you my PPT. Thank you. So as she's sharing the PPT, let me give a brief introduction about the topic. First of all, thank you to the Dean, Vice Chancellor, as well as the faculty coordinator for inviting me for this webinar. So this happens to be a very crucial and important topic. One of the reasons for that is, first of all, let's talk about criminal law, the relevance and importance of criminal law. As far as criminal law in India is concerned, first of all, so the journey of criminal law in India has been very long and arduous. And we have, like India is known for its unity in diversity, the same thing goes for its criminal law. We've not had one particular universal law for everyone. We have evolved through generations and centuries. So we started with the idea or the concepts of dharma that eventually with the passage of time, depending upon at what point of time who invaded India and was ruled by India, there have been additions in the criminal codes in India. Okay, so I think there was some disturbance. Yeah, sorry. So as I was talking, basically, so we've not had any uniformity as far as criminal law is concerned, but that changed only when Britishers came to India. So for them also, the intent wasn't to basically have a uniform system of laws for the benefit of the people of India. The idea or the intent of having a criminal law was, since they had entered in India as a trading company, the idea was to make laws feasible in a manner that the trading could be beneficial for them. But since that particular legal system worked and was universal in nature as far as its applicability was concerned, because up until the Britishers, different presidency regions of the country were following different laws. Those laws were primarily religious more than anything else. So the one thing that the Britishers did was they brought in a universality as far as the criminal laws was concerned. So I will be taking questions after my session, but if at all anyone happens to have any kind of question or doubt, you can also interrupt me in between. I don't mind that. Okay. Yeah, so as I was talking, the idea with which Britishers had brought in the criminal legal system. So one of the advantages was that they had brought in universality as far as the criminal legal system was concerned. It was universally applicable to the whole of India. That was one of the biggest advantages. But despite those advantages, there were various disadvantages. So something which has been very controversial time and again that you must have heard of is sedition. So sedition basically was a term which was incorporated with the intent that it will keep away all the reformists or the revolutionaries, which are speaking anything which could go against the present government at the time. So essentially, all the leaders that we had at that point of time, whether it was Mahatma Gandhi, whether it was Subhash Chandra Bose or Bhagat Singh, all of them at one point of time or the other were prosecuted under the sedition law. Why? Because the law was made with that intent that it could keep such kind of upheaval of such people in check. But then, despite getting independence, the problem was that during the time that we got independence, everything came in the controls of Indians. Now, it was very difficult at that point of time to manage or to rather overhaul everything which was existing at that point of time. So, we realized that it would make more sense if we continue with the same legal system that we have. Any which ways we follow common law. When I say we follow common law is basically we follow the system of law that has been given by Britishers. So much so that even today, majority of the laws that we have, irrespective of whether it is criminal or civil, is inspired from the common law system. So it made sense that we continue with the same legal system or the same criminal legal system. Now, since independence till 2024, of course, there have been various changes in the criminal legal system. But those changes were very short-term changes and very specific changes required for a particular act or a particular offense or a particular process. There has been talk about overhauling the criminal legal system since a very long time. But then changing of law in a country like India is also not an easy feat. So in India, we have both flexibility of laws as far as the laws are so stringent that the procedure of changing it is also very difficult. So that is also one of the reasons why it took us these many years to even change the laws. Srishti, could you go to the first slide?
Yes, ma'am.
The next one. Okay, yes. So as I was saying that majority of the legal system, rather the criminal legal system, has been inspired by the Britishers. Now, when I say inspired by the Britishers, one of the biggest disadvantages that we have for our legal system as of today is that it is very colonial in nature. Now, when I use the term colonial in nature, you would see certain difficult terminologies in the laws that we have, which is very difficult for us to comprehend and understand. So conscious effort has been made as far as with change lawyers or the law students or the judges. These are those kind of things which are applicable to even layman. But then the irony of this is that the language is so difficult and stringent that it becomes very difficult for a layman to comprehend it. And so they have no choice. Lawyer.
Yes,
Okay,
ma'am.
sorry, I thought that there was some network connectivity issue. Yeah, yeah. So as I was saying, so there are two things when it comes to passing of the law. The first one happens to be when a bill becomes an act, and secondly, when an act uh, when an act basically is implemented. So the difference is, so although these criminal laws received the presidential assent in the year 2023 itself, December of 2023, but then up until now, the applicability of these laws has still not started. Now, this is a gray area, which I think as law students you should be very aware of. Now, how this works is, so the moment a bill receives the presidential assent, basically it becomes a law. जैसे ही president sign कर देते हैं, that bill becomes a law. But then from what date that bill is actually applied, the law making from that act depends on gazette notification. पेपर्स आते हैं, जैसे आपके कॉलेज के नोटिफिकेशंस होते हैं, वैसे ही गवर्नमेंट ऑफ इंडिया will not begin its application. So despite the fact that ये तीनों laws जो हैं 2023 से ही इनको असेंट मिल चुका है, ये एक्ट बन चुके हैं, बट आज तक अप अंटिल टुडे ऑल्सो इनका इम्प्लीमेंटेशन स्टार्ट नहीं हुआ है. वाई? Simply because official gazette का notification नहीं आया था. Now that we've received the official gazette notification, we'll start the application of it, or the implementation rather, of these acts from June of this year. Right? I hope you understand the difference between these two things. Despite the fact that a bill becomes an act, it might not be implemented. The implementation actually depends upon the date of notification in the official gazette. Okay. So first of all, let's start with the intent. That what are the reasons why, मतलब ऐसी कौन सी जरूरत पड़ी या क्या जरूरत पड़ी जिसकी वजह से ऐसा लगा कि इन लॉज को लाना जरूरी है, या इनका इम्प्लीमेंटेशन होना जरूरी है, या इस तरह का ओवरहॉल होना जरूरी है. तो फर्स्ट एंड फॉरमोस्ट वाज that a lot of colonial colloquy was there. मतलब if you look at the previous, there was a concept of thugs. So all these things are there, but then आज की डेट में, आज के टाइम पे ये सारे लॉस का इम्प्लीमेंटेशन रिडंडेंट हो चुका है. ठीक है. Then if you read criminal law, the punishment. So in criminal law, there are two kinds of punishment. One is by way of fine, the other one is by way of imprisonment. Now, it was made in the year 1860. I'm talking about IPC. CRPC so basically fairly 100. Did I lose my connection?
No, ma'am.
Okay, sorry. Yeah. So the fine basically was that low, so much so that it became redundant. So basically, which meant is today, if I deceive someone and the maximum punishment for deception is a fine of 5,000 rupees or a fine of 500 rupees, I would rather just pay the fine. मतलब मैं prosecution करवा के fine even if I am found guilty, it is easier for me to actually pay the fine than to not commit the offense because of the outdatedness of that particular offense, right? So ये एक reason था, language एक reason था, outdated एक reason था. उसके बाद not that there have not been changes in the criminal law, there have been changes in all the three acts, whether it is IPC, CRPC or criminal law. There have been amendments over the course of years, but then those amendments have basically been in regard to a specific offense, in regard to the interpretation of a specific term. There has not been a complete overhaul. That's point number 3. Now, point number 4, back when these laws were made, so basically law and society always go hand in hand. Sometimes it is the society which initiates a change in the law. Other times the law initiates a change in the society. For example, there was a point of time that dowry was a practice which was ingrained in our culture. So it became a very normal thing कि हाँ dowry तो शादी के टाइम पे लेना देना बहुत easy चीज है और ये तो होना ही चाहिए. Then law came into effect saying that this is not something which is acceptable. This is against the principles of law. So despite the fact that the society wanted a practice of dowry to exist, but then the law put a nip in it कि नहीं ये गलत है, ये नहीं होना चाहिए. Basically, law की वजह से society बदली. Other times, like in the more recent years, we've seen advent of live-in relationships. Now, live-in relationship is basically that Indian society, which is often considered to be an orthodox society, has basically accepted certain modern concepts, one of which happens to be live-in relationships. Now, the thing is that live-in relationships weren't exactly recognized under the law. But law को ये समझ में आ रहा है that society change हो रही है and things like these are existing in the society, which basically meant that society initiated a change in the law. So much so that today the judges have categorically said that both the partners in a live-in relationship will have rights against each other. Children born out of such relationships would also be considered as a legitimate children. Basically meaning कि law and society go hand in hand. Now, these laws were made 100 years ago. आज का जो time है, we live in a technological world. This session is going on in an online medium. We are constantly on phone. Despite all of this, the legal system, especially the criminal legal system, is still very outdated. There is no technology involved in the legal system. So there was a need which was felt that sometimes a lot of processes could be made easier if at all we switch to online modes of whether presentation of witnesses is concerned. Sometimes the accused also cannot be presented in court. Sometimes either the accused is not able to be presented in court or the cost of bringing an accused to the court is so high that it is easier to actually hold that session through a video conferencing mode. So there was a need felt to bring in technology within the framework of the legal system. So these are essentially the reasons because of which a necessity was felt that let's change or amend. Now, changes and amendments have been happening over the years. The last one happened in the year 2018. 18 से 24 में बहुत ज़्यादा time का difference नहीं आया है. But the only thing that was different is in 18, very few changes happened. Those changes were basically triggered by Nirbhaya. right? So only a specific uh, law in regarding to the rights and protection of women were changed. Now, the last reason why we needed such kind of change is that today we are a more accepting and inclusive society. So if you look at the wording of the law, it essentially mentions he, and she is considered to be within the framework of the term he. Now, the law has changed to include the word person, which basically includes all kinds of people, all kinds of gender, whether it is a he, she, or a transgender. So, we needed a system or a law making process which is inclusive. ऐसा नहीं हो सकता ना that if supposedly I am a transgender, I shouldn't feel as if the law was not made keeping me into account. So, considering all of these things, there was a need or necessity felt that complete overhauling of law is required, which led to a formation of a specialized committee. So, can you go to the next slide, please? Am I audible?
Yes, ma'am.
Yeah, thank you so much. So, basically, there are three ways in which amendments or changes in lawmaking work. Let's go to all the three processes, and then I'll go to the third process. So the first one is piecemeal model. So what happens in a piecemeal model is that a need is felt to interpret, to change, to amend only one particular provision. So supposedly there is a confusion, there is a doubt in regard to the interpretation of a particular provision, like in case of rape. Although the framework of rape is such that it says that even consensual sex with a female below the age of 16 years, below the age of 18 years would amount to rape. Now, with the change in society, there was a need felt to basically talk about this age gap of 16 to 18 years. ठीक है, तो ये जो 16 to 18 years का age gap है, इसको इंटरप्रेट करने की जरूरत पड़ी, बिकॉज ऑफ विच द कोर्ट्स हैव आल्सो रिकॉग्नाइज्ड दैट 16 to 18 मतलब if it is a consensual sex with a person who's less than 16 years of age, it amounts to rape. But between 16 to 18 years of age, it might not amount to rape. So there are special considerations to be seen, basically depending upon whether consent was given, whether consent was freely given, and considerations like that. तो एक particular provision को change करना है ना, then piecemeal model comes into place. कि एक ही provision को change करना है, interpret करना है, amend करना है, things like that. Then is episodial model. Episodial model क्या होता है? Basically something happens, an event happens which triggers such kind of an overreaction, or rather a reaction from the society, that it leads to change. So as I was talking about the last amendment that happened in IPC, that was triggered by the Nirbhaya rape case that happened in Delhi. So because of the Nirbhaya rape case, changes were made in regard to offenses against women. Before that, after the bomb blast, we felt a need that we need to have stricter norms as far as terrorism is concerned. Then Tukaram case was the gang rape case that happened in Mumbai. So these are events. So essentially events which essentially evoke the collective conscience of the society to such an extent that it led to a change in the law. तो ये होता है episodial model. Then is comprehensive model. Comprehensive model is actually the most important, most relevant model. What happens in a comprehensive model is that a specialized committee is set up. The specialized committee is supposed to read upon what is existing, what the reasons of why the laws that we have presently, what were the reasons that the law making is such, why do we actually need to change the law? If yes, up until what extent can we change the law? So in a comprehensive model, suggestions from the general public is also invited. So different committees might have different models. So it could be a committee of judges, it could be a combination of judges, lawyers, legal experts. Then after giving a first draft, so like in the present criminal law, the first draft after it was introduced, changes or suggestions were asked from the general public also at large. So general public ने भी अपने suggestions दिए, whether those were people from the law background or whether those were people not even from the law background, wherein they had given their own suggestions कि हमें ऐसा लगता है कि इस law में ये changes होना चाहिए या इस तरीके का कोई punishment को incorporate करना चाहिए. Things like these were suggested, and things like these were suggested, and accordingly those changes were made. ठीक है? Does anyone have any doubt up until this point? Okay.
No, ma'am.
So now
We can continue, ma'am.
Okay, thank you, Jean. So as I was saying, that there were certain reasons which led to the changes in laws. So I'll start with the Evidence Act, and we'll go to then we'll go to CRPC, and then we will go to IPC. So I'm trying to give a brief idea of what kind of important and pertinent changes were added in these respective laws, which are relevant to know for law students as well as non-law students. So the first one was Evidence Act. Now, the important thing as far as Evidence Act is concerned is, as you can see, that today that has added 170 sections. Okay, sorry. Today it has 170 sections as opposed to the earlier 166 sections. Now, the important changes in the Evidence Act, there were two important changes which are very relevant for everyone to know. First of all is introduction of electronic evidence. Now, when I say introduction of electronic evidence, what used to happen prior to this is that a WhatsApp conversation, a video recording, or an audio recording, these were evidences which were not admissible in the court of law. Now, there is a justifiable reason also for that. The non-admissibility was because tampering of such kind of evidences is very easily possible. So, that is one of the reasons that in the previous amendments also, these kind of changes were not incorporated. But then understanding that we live in a technological age, we cannot run away from technology. Also, majority of the conversations, majority of the things either are happening in an online mode. There could be a CCTV image or a CCTV video of an event happening. So that could be used as an admissible evidence in the court of law. I might be having a personal private conversation with an individual talking about committing a crime, having committed a crime, or thinking of committing a crime. That kind of conversation also can be presented in the court of law as a WhatsApp chat. Couple of considerations need to be kept into mind while doing that, which is to check into the authenticity of such kind of evidences. Why? Because it is easier to tamper these kind of evidences also. So although it has become admissible, the authenticity of these evidences is to be checked or taken into account. Now, next one is forensic evidences. Now, you must have seen in like American shows that a crime happens, the police comes in, and along with the police, a forensic team comes in. So a forensic team basically collects the evidences right there. The problem with India was that we weren't technologically advanced to have a huge framework as far as forensic collection of evidences is concerned. Although one of the biggest disadvantages of that is we still do not have a comprehensive framework as far as collection of evidences is concerned through forensic medium. But at least we are, so there are institutions, but then because of the number of cases, it becomes very difficult for that team to be able to reach each and every scene of crime. So, but despite that, the problem, the point that I'm trying to make is that, so how a criminal law works, let me talk about a little bit about that, is how a criminal law works is the onus is essentially, please go to the previous slide only, I'm still talking about that. Yeah, so how criminal law basically works is there are two sides. One is prosecution, the second one is defense or accused. So the responsibility of the prosecution is higher. How is the responsibility higher? The prosecution is supposed to prove the case beyond reasonable doubt, and the defense, all it has to do is create a doubt that there could be a possibility that instead of me, someone else could have been there. There is a probability that the evidence is given by the prosecution, there is a lack or there is a lag in the chain of evidences. So just by proving those small lags, which are generally technical details or technical faults from the part of police while doing their investigation, while collecting the evidence, because of those technical faults or lacunas, an accused is let go of. Because that is how the criminal justice system in India works. Now, this particular problem can be curbed by forensic collection of evidences when we have proper filing system, when there is no lag in the chain of evidences. So if I am the one collecting the evidence and I am the one who's supposed to submit the evidence in the evidence room, there shouldn't be a third person in between. There shouldn't be contamination of the evidence that I have at hand. Things like these are essentially kept into consideration while framing forensic collection of evidences. So this is also one important feature. Okay, Karthik, you're talking about sedition as far as I saw a question asking about the sedition in the previous law and sedition in the current law. I will get to that when I'll get to IPC. I will specifically talk about that. Although there hasn't been much change, just to give you a brief idea of what you asked, there hasn't been much change. Even after the amendment, there has been a lot of confusion as to what exactly amounts to sedition. Okay, so now moving on to CRPC. Can you go to the next slide? Okay, so CRPC originally had 484 sections, which are now been converted into 534 sections. Sorry, 531 sections. Now, there have been various changes made in the CRPC also. I'll go to all of those points one by one. First is Directorate of Prosecution. Now, Directorate of Prosecution is something which has been incorporated for the first time in the criminal justice system itself. Now, what the Directorate of Prosecution does is that every state will have a Directorate of Prosecution. In every district, there are basically three levels. There will be deputy director and assistant directors, which are entrusted with the responsibility of ensuring what kind of case is at hand, depending upon the final punishment of the case. So basically, three kinds of demarcation have been made here. Punishment wherein cases wherein the punishment is less than 5 years. Punishment wherein, cases wherein the punishment is between 7 to 10 years. Cases wherein the punishment is more than 10 years. So the responsibility of Directorate of Prosecution is to see whether, so basically cases go by hierarchy from the lowest court to the highest court. So they might start from the judicial magistrate first class and then might go to the Supreme Court. So Directorate of Prosecution is essentially entrusted with the responsibility of seeing the kind of evidences that are there, the kind of arguments that are made, and to ensure that no law point has been missed as far as the justice delivery of a particular matter is concerned. If at all that law upon the punishment, that particular head will get to decide whether we should go to appeal for such matters or not, whether it is worth going to appeal for such matters or not. Now, what this will do, this basically is, so one of the things which plagues the Indian legal system is pendency of cases. Thus, basically, by the time a matter starts, from the time a matter starts, that a matter is finally disposed of, even if I keep going in appeal, it could take years. And I still not, as a victim, I still might not even get a favorable judgment. So that is a lot of time, effort, energy, all gone down the drain for an individual. But then the same amount of wastage happens from the side of the state also. Because how the criminal system works is that an individual isn't the victim. The state is the victim. The state files a case on your behalf. So the state is investing. Time, effort, and money. So in order to keep a check that unnecessary pendency is not created, the idea of Directorate of Prosecution was introduced, which will essentially keep a check whether a case even requires an appeal. Sometimes people go in appeal out of spite, out of revenge, just to prove a point that, or just harass the other party. So the intent of Directorate of Prosecution is to keep all of these things in check, right? Then, as I was saying, next is victim-centric justice. As I was saying, that a victim in a criminal matter is a mere witness in their own matter. What I mean to say by that is, supposedly I am a victim of violence. A theft has been committed against me. My responsibility to that effect stops after I have gone and registered the FIR. Now the state machinery will come into effect. अब स्टेट का काम होगा एफआईआर लिखना, एफआईआर की बेसिस पे इन्वेस्टिगेशन कंडक्ट करना, इन्वेस्टिगेशन की बेसिस पे चार्जशीट सबमिट करना, चार्जशीट की बेसिस पे कोर्ट में ट्रायल डेट आएगी एंड देन ट्रायल, कोर्ट का ट्रायल स्टार्ट होना. आई हु वाज द रियल विक्टिम, मेरा यहाँ पे कोई रोल ही नहीं है. The only role that I will play is I will be called to the court as a witness कि आपने कुछ देखा, आपको कुछ पता है, तो विटनेस का एग्जामिनेशन एंड चीफ एंड क्रॉस एग्जामिनेशन हो सकता है. अदर देन दैट मेरा कोई रोल होगा ही नहीं. सो दिस इज अनदर प्रॉब्लम. So I give you an example of a matter of theft, but there was a PIL, sorry, there was a RTI filed as to how many victims of rape have received any kind of assistance in terms of victim protection, or in terms of any kind of state protection by the state in providing them a place to stay, or help in starting afresh, things like that. So after that RTI, it was realized that only 0.1%, मतलब रेप के विक्टिम में 0.1% ही ऐसे विक्टिम हैं जिनको किसी भी तरीके का असिस्टेंस मिला है, किसी भी तरीके का प्रोटेक्शन स्टेट ने अपनी साइड से दिया है, which basically means that a victim of rape, first of all, the first and foremost thing that a victim of rape requires is protection, counseling, protection from the side of the state, counseling which is state sponsored because not all victims can afford. Third is protection of their privacy. Now, if the state is not providing all of these basic rights, the downside to that is that victim can easily be threatened by the opposite party. तो विक्टिम खुद ही अपने मैटर में गलत स्टेटमेंट देके आ जाते हैं, क्योंकि उनको चाहिए कि ये जो ऑडियल हो चुका है ना, इसको खत्म करना है, इसको अब आगे नहीं बढ़ाना है. And the problem with that is, if a victim wants to get away from all of the criminal justice mechanism, तो जितना भी टेकिंग ऑफ एविडेंस एंड कलेक्शन ऑफ एविडेंस होता है, ये लोअर कोर्ट की स्टेज पे होता है. तो इवन इफ द स्टेट वांट्स टू गो इन अपील, जब एविडेंस कलेक्शन ही गलत हुआ है तो विक्टिम को कभी भी जस्टिस मिलने का पॉसिबिलिटी ही नहीं रह जाता है. तो इसलिए सबसे पहली रिस्पॉन्सिबिलिटी जो स्टेट की आती है वो ये है that the criminal justice model should be made to favor the victims, to protect the rights of the victim. Right? So this is, so the new model in the CRPC basically talks about providing protections to the victim and ensuring that responsibility upon the state to provide that kind of protection to the victim. Then, yeah, I am getting to 0 FIR also. So this is one, this is another advantage. Now, police accountability and transparency. Now, after the DK Basu judgment, so DK Basu judgment had given extensive guidelines कि पुलिस को FIR के बाद किस तरीके से अरेस्ट करना चाहिए, अरेस्ट के क्या क्या प्रोसेसेस होते हैं, उनको किस तरह से फॉलो करना चाहिए. नाउ एविडेंस ऑल्सो सेज दैट एनी काइंड ऑफ कन्फेशन इन द पुलिस स्टेशन इज नॉट एडमिसिबल इन द कोर्ट ऑफ लॉ. मतलब अगर आपने पुलिस के आगे एडमिट कर भी लिया है, तब भी आप जब तक जज के आगे एडमिट नहीं करते हैं, आपके अगेंस्ट कोई चार्ज नहीं लगेगा. ठीक है, आई एम गेटिंग टू द एफआईआर पॉइंट, जस्ट गिव मी सम टाइम. ठीक है, तो बेसिकली पुलिस अकाउंटेबिलिटी एंड ट्रांसपेरेंसी जो है डी के बासु के बाद, वो जो थर्ड डिग्री की जो हम बहुत केसेस सुनते थे, जो हम बहुत सारे केस इंस्टेंसेस ऑफ डेथ इन कस्टडी सुनते थे, ये सारे इंस्टेंसेस हैव कंसिडरेबली रिड्यूस्ड डाउन आफ्टर डी के बासु गाइडलाइंस and incorporation of those guidelines in the evidence and CRPC. But despite that, there are still ways and means or measures through which sometimes the police, so basically criminal law is supposed to maintain a balance, collective right of the society and individual right of the accused. तो अगर आप किसी को arrest भी कर रहे हो, तो despite the state making that arrest, that individual also has certain rights. So you can't infringe upon those rights. So in order to ensure कि accountability रहे police personnel की और transparency maintained रहे, there have been provisions which has been added in the new act, which talks about videographing when an arrest has been made. Two people जो witnesses होते हैं arrest के time पे, they can also videograph the entire process of arrest. Videographing when collection of evidences is also happening. So basically what all of these can ensure is that अगर कोई police atrocity हो रही है, and if at all the police is in any way using more power than is required, then in that case you can easily present that evidence in the court of law. तो आप पुलिस अकाउंटेबिलिटी को बहुत पुलिस अट्रॉसिटी को एक चेक में रख सकते हो, एंड देयर इज अकाउंटेबिलिटी फ्रॉम द साइड of the police. Now, someone had asked a question of FIR. So one of the new things that have been introduced is the concept of zero FIR. तो I think movies में बहुत देखा होगा या सुना होगा या generally भी पता होगा that basically पुलिस वाले क्या बोलते हैं, ये इंस्टेंस हुआ, अरे ये हमारे jurisdiction में नहीं आता है, ये उधर जाओ. उधर वाले बोलते हैं अरे ये हमारे jurisdiction में नहीं आता है, उधर जाओ. So a person who's already been traumatized or has been a victim of crime keeps running from one police station to another police station justifying कि भाई ये आपके jurisdiction में आता है, प्लीज मेरा मैटर ले लीजिए. So this problem has been, at least the immediate effect is to try and solve this problem by introducing the concept of zero FIR, which basically means that you can now register an online FIR irrespective of the jurisdiction. Now the responsibility lies with the police कि जो आपने FIR लॉन्च की है वो within 15 days of you lodging that FIR, जो करेक्ट उसका jurisdiction है वहां पे पहुंचे. ठीक है, okay, yeah, and then modernizing legal process. And so basically what used to happen was कोर्ट डायरीज होती हैं, पुलिस डायरीज होती हैं, हर चीज को डायरी में लिखा जाता है, एक डायरी एंट्री की जाती है. देयर हैव बीन सो मेनी इंस्टेंसेस व्हिच एट द स्टेज ऑफ द एविडेंस इन द कोर्ट आल्सो हैज बीन रियलाइज्ड कि यहाँ पे देयर हैज बीन अ टेम्परिंग. ओरिजिनली कुछ और लिखा था, देयर वाज उसको काट के कुछ और कर दिया गया है. all of these lacunas can easily be removed by keeping the entire system on an online portal. So from the time a complaint has been registered to the time a charge sheet is filed, all of this has been kept on an online portal. So as an individual आपको पता भी चल सकता है कि आपका जो मैटर है वो कौन से स्टेज पे है, वो किस प्रोसेस पे या किस पर्टिकुलर अभी मतलब इन्वेस्टिगेशन चल रहा है या अभी ट्रायल की डेट आ चुकी है. ऑल ऑफ दैट वन कैन हैव इजी एक्सेसिबिलिटी टू. Another thing which is introduced is that the trial date basically, खैर वो तो आज की डेट में भी है, that investigation should basically end within 60 days and the trial should investigation end हो जानी चाहिए 60 days तक, and accordingly charge sheet भी file हो जानी चाहिए. But then the downside of that is that because of the pendency of cases, even if the police personnel are trying their best to conduct the investigation. The pendency is such that एक मैटर का इन्वेस्टिगेशन हो सकता है, बट 10 मैटर्स का इन्वेस्टिगेशन करके उसका चार्जशीट फाइल करना बिकम्स ह्यूमनली डिफिकल्ट. तो ऑल्दो इसके बारे में बात की गई है बाय सेटिंग स्पेसिफिक डेट्स कि ये वाला प्रोसेस 30 डेज में हो जाना चाहिए या मैक्सिमम 45 डेज में हो जाना चाहिए. But then the population to the police personnel ratio is so high that it becomes very difficult to keep a check on that. Now, another thing is, I don't know whether you know the concept of basically police custody. So, police custody is when a person is brought to the police for asking of questions. कुछ questions पूछने होते हैं. So, there is a person who's accused for murder. तो उसको पुलिस कस्टडी में भेजा जाता है. तो जनरली द पुलिस कस्टडी यूज्ड टू बी 14 डेज. उसके बाद जज डिसाइड करते थे whether there should be an extension in the custody or not. And this is one of the very essential aspects of criminal law because it talks about the individual liberty also. तो यहाँ पे जो पुलिस कस्टडी का टाइम ड्यूरेशन है, that has been increased. That it can even go up to 60 days, depending upon the brevity or the seriousness or the gravity of the matter or the seriousness or the heinousness of the matter. So, actually, this kind of provision has both its advantages and disadvantages. The advantage is the police now will have more time to investigate or to basically inquire. But then the downside of that is जितना ज्यादा एक इंडिविजुअल पुलिस कस्टडी में रहता है उतनी ही ज्यादा प्रोबेबिलिटी होती है उसके राइट्स इन्फ्रिंज होने की. तो यहाँ पे जो ओरिजिनली 14 डेज ही था, अब वो 14 डेज बढ़ के 60 भी हो चुका है. तो इसका मतलब ये है कि इफ अ पर्सन इज स्टेइंग इन द पुलिस कस्टडी फॉर 60 डेज, समटाइम्स आउट ऑफ शेयर एग्जॉशन और वांटिंग टू जस्ट गेट आउट, he might give false evidences, or basically the police will have a longer time to use third degree measures, which although is not legally allowed, but still continues to happen even to this date. Okay, can you move on to the next slide? Okay. So IPC basically, as I had started with, basically talks about two kinds of punishment. One is either you pay fine or there is an imprisonment. Now for offenses of less heinous nature, basically जो cognizable offenses होते हैं, छोटे मोटे offenses होते हैं जिसकी punishment less than 2 years होती है, उन तरह के offenses के लिए जरूरी नहीं है imprisonment हो. Because the idea of punishment in India, we follow a reformative. So basically we follow death sentence also, but primarily we follow a reformative form of punishment. So, so the intent is एक क्रिमिनल को क्रिमिनल नहीं बनाना है, एक क्रिमिनल को ये रियलाइज कराना है कि उसने जो किया वो गलत किया, एंड ही शुडंट प्रोबेबली रिपीट द सेम थिंग अगेन. ठीक है. So उसके लिए उसको हर present survey, it basically shows that majority of the jails in India are overcrowded. For a jail which has a capacity of 100 prisoners, it is actually accommodating 10,000 or 1,000 prisoners. तो ये इतना जो लैग है इसको भी कम किया जा सकता है by basically giving lesser degree of punishment in terms of community service. Then IPC may, as I had talked about in the beginning also, that IPC has become more inclusive. Earlier, IPC only used to have male pronouns. हर जगह he लिखा हुआ था. And definition clause में the word he was interpreted as कि he है मतलब हम उसको assume करके चलेंगे she भी है, unless otherwise stated. ठीक है. अब उस demarcation को exclude कर दिया गया है. Now the word is person. तो जहां कहीं पे भी any kind of individual is required, वहां पे person लिखा जाता है. Now someone had asked about sedition, that what was sedition in the previous I think in the beginning only, someone has asked about sedition. तो बेसिकली सेडिशन का जो अभी करंट लॉ में डेफिनेशन है ना, इट बेसिकली सेज एंडेंजरिंग द सॉवरेनिटी, यूनिटी एंड इंटेग्रिटी ऑफ इंडिया. सो एंडेंजरिंग द सॉवरेनिटी, यूनिटी एंड इंटेग्रिटी, ये तीन चीजें एंडेंजर करना, either through your words or through your actions or through electronic means also. यहाँ पे आप आर्म्ड रिबेलियन को भी कवर कर रहे हो, किसी तरह का सेपरेटिस्ट एक्टिविटीज को भी कवर कर रहे हो. अब इसमें एक प्रॉब्लम आ जाती है, व्हेन वी सी or when we try and interpret the word sovereignty, unity and integrity. So a lot of people previously जो पहले वाला आईपीसी है उसमें सेडिशन की वजह से 124A में सेडिशन था. A lot of journalists, a lot of right-thinking people who had questioned the actions of the government were also booked under that law because the definition was that vague. But then the irony of the situation is that the present definition, although when the government introduced the current legislation, it said that newer definition has been introduced and there is no doubt or there is no confusion. But then the newer definition also basically is borderline confusing and it's very vague. And the interpretation of that can actually go against anyone who is acting as a whistleblower for the actions or the activities of the government also. So to answer the question that someone had posed before, that the current definition of sedition is as vague, inconclusive as it was in the previous legislation. In fact, the present definition actually उसको थोड़ा सा वाइड कर दिया गया है उसके स्कोप को, because electronically speaking also has been covered into the word sedition, which basically means मैंने अगर आज सोशल मीडिया पे कोई पोस्ट लिखा saying that the election system in India is flawed in the sense that the present government is trying to take over this entire system, जिसकी वजह से कुछ लोग इंसाइट हो जाते हैं. सो एज अ फैकल्टी, माय स्टूडेंट्स हु फॉलो मी, स्टूडेंट्स आर लाइक मैम ने जो बोला बिल्कुल सही बोला एंड वी शुड स्पीक अगेंस्ट द गवर्नमेंट, देन आई कुड बी बुक्ड फॉर सेडिशन आल्सो. सो because the interpretation of the present definition of sedition also is as vague, is what I am trying to say. Okay. So in the previous IPC also, specific classification of offenses was made. So classification of offenses क्या मतलब है? Offenses against body, offenses against women, offenses against property. In the present IPC or in the भारतीय न्याय संहिता, इसमें specific classifications दिए गए हैं of offenses against women, children, human body. मतलब उसको categorize किया गया है. There is no like मिक्सिंग ऑफ की women and children जो है वो सेम कैटेगरी में आते हैं. Okay, another thing is I was talking about the age of consent. As far as rape is concerned, the previous legislation had written the term 16 years. तो वो 16 का जो 18 था एरिया एज था वो बहुत ग्रे एरिया में था, wherein lot of Supreme Court judgments, even High Court judgments, there was vagueness in terms of the fact that sometimes consensual sex by a 17-year-old female led to rape. Other times by another court it did not lead to rape depending upon the circumstances. तो अब उस confusion को remove कर दिया गया है, which basically says that the age of consent is 18. Okay, the present legislation also touches upon, so basically pehle, as I was talking about how amendments are made, I had talked about how an event sometimes leads to an amendment. So the 1993 bomb blast and around the same time bomb blast in different parts of the country had led to the formation of an enactment by the name of TADA. ठीक है, उसके बाद so it was a separate legislation. Now the current legislation, the current BNS also talks about terrorism, that the punishment for terrorism in extreme cases, or rather in extreme majority of the cases, is 10 years life imprisonment or death. Uh, although उसमें भी थोड़े से let's not go there because I don't think I will be able to cover that if I open that Pandora's box. Now, one of the disadvantages in today's BNS is that although there have been a lot of discussion as far as the introduction of marital rape is concerned, but despite a lot of suggestions made by the general public, by legal experts too, the present legislation still is silent about marital rape. So this happens to be one of the disadvantages of present BNS. But then another advantage is when we were talking about electronic evidences, another thing that the present legislation has introduced by way of section 356 in BNS is that पहले क्या होता था, डिफिकल्टी कहाँ आती थी कि अगर अक्यूज्ड प्रेजेंट नहीं है ना तो ट्रायल शुरू नहीं हो सकता. Why? बिकॉज आप एब्सेंशिया में कभी कोई ट्रायल नहीं कर सकते हो. तो डिफिकल्टी या चैलेंज ये है कि अक्यूज जो भाग गए हैं, जो हु फ्लेड द कंट्री, उनको पहले कंट्री में लेके आना है. जब वो कंट्री में आ जाएंगे उसके बाद ही उनका ट्रायल स्टार्ट हो सकता है. अब दिस पर्टिकुलर challenge has been removed by incorporating the provision that online trials हो जाएंगे. One, even in absentia. So even if the accused is not present, the trial can still continue and start. So abhi most recently people like Vijay Mallya, Dawood Ibrahim or Neerav Modi who fled the country, causing crores of losses in property, can easily be prosecuted under the new regime of BNS. Can you go to the next slide? Okay, I did not realize that I'd specifically mentioned that. Yeah, so basically I had specifically talked about sedition in here, that how sedition, although has been added, but then the challenges which were faced by the previous legislation of sedition are still existing. It is still as ambiguous, and it still has the probability of infringing upon the individual rights of a person. Then again, concepts like mob lynching, terrorism, organized crimes have also been introduced into the penal legislation. I think that's about it. I can, if anyone happens to have questions, please ask. Let me see if there are any questions in the chat box. Okay, I think I've answered the questions which were there in the chat box. If at all anyone happens to have any other question, they can also ask.
I think there is no more questions, ma'am.
Okay. I hope I've been able to communicate the basic idea of the 3 laws that have been introduced recently.
So I would like to conclude this webinar. Good afternoon, everyone. I, Geeny Mourya, on behalf of Department of Law, would like to propose heartfelt thanks to our speaker, Dr. Aditi Singh, for gracing today's webinar. Ma'am rightly stressed and talked about the reforms in criminal law, a comprehensive overview of the significant changes in India's criminal law as of 2024. These comprehensive reforms are not mere judicial actions, but reflecting India's sovereign commitment towards national security. Thank you, ma'am, for sharing knowledge with us. I would like to express profound gratitude to our Vice Chancellor, Professor Dr. K.R.S. Rangasiva Rao sir, and Pro Vice Chancellor, Professor Dr. Vinita Kaur Saluja ma'am, Dr. Neeraj Prakash Rai sir, and all the respected professors, colleagues, and all the participants. Once again, I thank all for your support.
Thank you so much,
Thank you
Geeny.
so much. Thank you so much,
Thank you
ma'am.
so much, Srishti ma'am, Vice Chancellor Sir,
Thank you.
Dean ma'am, for having me. It was a pleasure giving this session.
Thank
Thank
you so
you.
much, ma'am.
Okay.
All the students, you can fill this